Hello everyone, and welcome to our show Ask an Expert, where I get to ask the questions and the expert will get to answer them. My name is Peter Weber and I'm with Angle and Focus in Savannah, Georgia. And today we have Billy Norse with Weissman Law with us, and he will be talking about probate. Welcome, Billy. Tell us a little bit about yourself.
Let's see. Well, good to be here, and thanks for having me. And I'm an attorney here in Savannah at Weissman Law, and I focus on real estate and probate.
So let's get right into it. Why should I have an estate plan? What is it for?
Well, an estate plan is really for your family. So it's a way to make things easier for your family when you pass away. It's a plan on how your assets should pass and who they should go to. So if you don't have one, there could be some confusion or some issues moving forward with your family as to who gets what.
That kind of answers my next question, is what happens if I don't have a will?
Well, so Georgia's its own state, which means it's different than other states in this process. But as far as Georgia's concerned, if you don't have a will, there's a progression of who gets what, okay? And it starts off with your spouse, and then it goes to your children. So then what it does is it looks for the next available heirs. Now this could cause complications, because if you're married and have children and you don't have a will, well, what Georgia law is going to do is it's going to try to divide the property between your spouse and your children. Now, on its face, that might not seem like a big deal, but the problem is who wants their wife or their husband to share property with minor children or their children? Most people want all the property to go to their spouse, and then let the spouse allocate the property to your children once the spouse passes away.
So how do I protect my home equity when I get older?
Well, if you have a will or some type of estate plan, they'll do that. Another thing you could do is you could do certain documents like a power of attorney, healthcare power of attorney, things that allow people to step in your shoes and make financial decisions for you. And in case, you old age or, you have dementia or something like that, and no one could take advantage of you.
And if the case happens, so what's the first step in selling my home for a family member?
For a family member that's passed away? Yeah, so the first thing you want to do is, I'd say, once you get through the funeral and some of the stuff that's very important, is talk to an attorney. And the reason why is there are some options that are only available within 2 years of someone passing away. This can make it a lot easier on the family to sell the home. All right. Another thing that happens if you wait too long to consult an attorney and find out how to sell your home, there could be other people that pass away that are also heirs, and we do see this from time to time. For instance, you might have the husband passes away, the wife stays in the home, the husband's interest in the home is never probated, and then the wife will pass away. So then when the children get involved, now they've got 2 probate estates to take care of, and that could be very overwhelming to the family.
How long can it take to sell a home in probate?
It depends, just like a lot of things. But if you have a will that's very clear and the family is all on the same page about, cooperating and moving forward with probate, you could usually get in and out of probate court in about a month. Yeah, and oftentimes we'll work with realtors so that, once we filed something in probate court, then we could go ahead and list the property, because we're confident that by the time it comes up to a closing or, gets under contract, that we'll be through with the probate process. Now, if you don't have a will, it could take much longer, okay? Because in that case, we have to run a publication period in the newspaper. There's more chance for uncertainty, for other things to come up, little surprises. But, even if that goes smooth, we're looking at maybe 2 to 3 months to get it through probate.
What happens if there's more than one beneficiary?
Well, if you have an executor, which means you have a will that names somebody, the executor is most often charged with administering the estate. So if it says in the will, I leave all my property to my 3 children, the executor will have the power, most oftentimes in wills, to sell that property and then allocate the proceeds to the children. It gets more complicated when you don't have a will, which is another reason why you should have a will, where, when I said that the law tries to allocate the property among the spouse and children, it's harder for the administrator to sell that property. The default would be is just to allocate the property equally to all those, to the children and to the spouse or just to the children, and then you'd have to get all three of them to cooperate in that case on the sale. Now you could go around it and go to court and seek a court order to sell, but again, you're requiring family members to cooperate and be on the same page.
Definitely complicated process that you don't want to take on yourself.
Yeah, I mean, it depends on how many assets you got. And then how large the family is, but oftentimes we see with probate of estates, if it's just the spouse, then things pass pretty smoothly. It's not a complicated process. But the more family members you got and, multiple properties or things like that, then it becomes overwhelming.
Billy, thank you so much. Great information. I think we learned a lot today.
Okay, great. Thank you.
And thanks to all of you for watching. If you're watching us on YouTube, make sure to like us and subscribe to my channel and hit the notification bell. If you are watching this on Instagram or Facebook, be sure to like this video and follow my page to stay up to date on everything's happening in Savannah and real estate. Until next time.